Hi. Okay, guess we're starting now. Welcome everyone to the latest webinar from the ABA section of Civil Rights and Social Justice, brought to you in conjunction with our colleagues in the ABA section of International Law. A quick plug, if you like our work, we invite you to become a member of the Civil Rights and Social Justice section and collaborate with us on projects you want to develop or offer our members and the general public. During today's program, you can ask questions of our panelists by finding the questions drop-down box on the right-hand side panel and typing in your questions. There will be time at the end for our panelists to address them. Also on the panel is a handouts drop-down where you can access written materials relevant to today's discussion. So we will be sharing a recording of this program with the handouts to everyone who is registered so that you can share it widely with your networks or look at it after the program. Please feel free to leave us feedback or ask questions to follow up as well. And with that, we'll get started with a short introduction, and then I'll introduce our panelists, and then we'll get going on today's discussion. So we're thrilled to bring you today's program entitled Overcoming the Use of the Veto by the Permanent Members of the United Nations Security Council in the Face of Atrocity Crimes. Our panelists today are Mohammed Al-Abdullah, Ambassador Hans Carell, and Professor Jennifer Trahan, who will discuss the role of the veto by permanent members of the Security Council in the face of atrocity crimes, the legalities of the Security Council veto by members in these situations, and steps that might be taken to overcome the political bludgeon that the veto has become. In brief, just so we're all on the same page to start, the United Nations Charter confers on the Security Council the primary responsibility for the maintenance of international peace and security. The Security Council is made up of 15 members, including elected non-permanent members and 5 permanent members, which are the US, United Kingdom, Russia, France, and China. And those permanent members have the power to veto Security Council resolutions and action. While this responsibility has resulted in many actions that seek to address mass atrocity situations, from condemnation to sanctions and referrals to international tribunals, at times permanent members of the Security Council have also used their veto power to thwart efforts to address mass atrocities and serious violations of human rights in those same ways. So with that being said, I'm going to introduce myself and the panelists, and then we'll get started. I'm Kristin Smith. I'm a staff attorney for the criminal justice section here at the American Bar Association, where I work on issues involving international criminal justice and the prevention and accountability for atrocity crimes. I also serve as director of the ABA's International Criminal Court Project, an initiative which seeks to build greater awareness of the International Criminal Court in the United States through education, advocacy, and practical legal assistance. And now our panelists, we have a great panel for you today, the first of which is Mr. Mohammed Al-Abdullah. Mohammed Al-Abdullah is director of the Syria Justice and Accountability Center, which is a Syrian-led nonprofit organization and recent recipient of the Anne Frank Special Recognition Award that works to ensure that all human rights violations from all sides of the Syrian conflict are well documented, preserved, analyzed, and securely stored. The organization has contributed to war crimes units and prosecutions and provided evidence on multiple criminal cases in Europe and North America, as well as specific investigations conducted by the UN Commission of Inquiry. Mohammed is a Syrian human rights and democracy researcher and activist prior to 2011, and is also a former prisoner and survivor of torture who was imprisoned in Syria on 2 separate occasions for his work defending human rights and lobbying for political reform. Our next panelist is Ambassador Hans Carell. Ambassador Carell served as Undersecretary General for Legal Affairs and the Legal Council of the United Nations from 1994 to 2004. Before joining the United Nations, he was Ambassador and Undersecretary for Legal and Consular Affairs in the Swedish Ministry of Foreign Affairs from 1984 to 1994. Ambassador Carell has been a member of Sweden's delegation to the UN General Assembly and has several assignments related to the Council of Europe, OECD, and the CSCE, which is now the OSCE. Together with 2 other rapporteurs, he was author of the CSCE proposal for the establishment of the International Tribunal for the former Yugoslavia, transmitted to the United Nations in 1993. He was the Secretary General's representative at the 1998 UN conference that adopted the Rome Statute of the International Criminal Court, and was also involved in the establishment of the International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, and the Extraordinary Chambers in the Courts of Cambodia. Last but not least, our last panelist is Professor Jennifer Trahan. Professor Trahan is a clinical professor at NYU Center for Global Affairs. She served as counsel and of counsel to the International Justice Program of Human Rights Watch, Iraq prosecutions consultant to the International Center for Transitional Justice, and has worked on cases before the Special Court for Sierra Leone and the International Criminal Tribunal for Rwanda. She's published 2 digests on the case law of the ad hoc tribunals, as well as scores of law review articles and book chapters, including on the International Criminal Court's crime of aggression. She also served as one of the U.S. representatives to the Use of Force Committee of the International Law Association and is chair of the American branch of the International Law Association's International Criminal Court Committee. She's also worked on a book entitled Legal Limits to the Veto in the Face of Atrocity Crimes, which is under contract with Cambridge University Press. So with that, we'll get started and jump in. My first question is going to Professor Trahan. To start, can you set us up with some examples of where this dilemma, the use of the Security Council veto in atrocity situations, has been confronted in the past, and perhaps describe more specifically what the problem is with the veto being invoked when there are ongoing atrocity crimes?
Great. Thank you, Kristin, and also thank you for your help in setting this up. And I'm really pleased at the ABA's interest in this topic. And looking at this. Just to say, we're talking today about the veto, but I think equally problematic is sometimes the threat of the veto. And there's also something called basically the silent veto, and that is where a country's political alignment is such that measures are not even put to the council, resolutions are not drafted, things are not proposed. So sometimes there's paralysis of the council, but you have no express vetoes, but it's actually attributable to the veto power. So if we go back historically, there was significant veto use by the US, UK, and France in the Apartheid era regarding South Africa. It didn't result in complete paralysis. The Security Council was able to impose eventually mandatory sanctions. Historically, in the face of the Rwanda genocide, again, there are no express vetoes, but both France and the US had the position that the Council must not mention the word genocide in its resolutions, and they were opposed to sending more robust forces. So this opposition, I think, is because of the veto power. The US, of course, uses the veto extensively related to Israel. And I'm going to save it for Mohammed to discuss the situation in Syria. But of course, we've had 12 vetoes in the face of massive atrocity crimes. Regarding Darfur and Sri Lanka, there were no express vetoes. But again, I think this is attributable to China's veto power, that a lot of measures that one could envision were simply never proposed. And sometimes the threat of the veto results in significant delay in the imposition of sanctions or in any kind of peacekeeping deployment. And we've also most recently seen this in Myanmar, where the Security Council is doing very little. There was one express veto already years ago, would have condemned the atrocity crimes, and that gets blocked by China. And of course, the veto is not only blocking the council, but I think it's also sending a message to perpetrators on the ground, to regime actors. And you have essentially a protector on the Security Council. So don't fear about accountability, because resolutions simply can't pass. So it seems a really pernicious use. So there's a quick overview of what we're talking about.
That's great. Thank you so much. And Mr. Al-Abdallah, I'll go to you next. Could you help us understand how this process and problem has played out in the Syria conflict specifically?
Absolutely. As Jennifer articulately basically stated, the use of veto, or the threat of the use of the veto, was put in place in the Syria context very early into the game, as early as 2011, when the statement was coming from, or the resolution from the Security Council was merely to condemn the use of violence, wasn't even deciding sanctions or military actions or any of the basically topics or ideas you might think a nation will veto. The second veto, and this is more as the progress of the conflict in Syria continued and the opposition started to pick up arms and the government started using more heavier arms. So the condemnation of the use of excessive violence was double vetoed as well, Russia and China. And China tagged along with Russia and lots of those vetoes. At some point, Russia faced the entire world in this, but that's one side of the problem. When one nation can provide ultimate protection to human rights perpetrators, especially in the case where we're talking about gross human rights violations, war crimes, or atrocity violations, let's say. So more progress in the Syrian conflict, you will see clearly how the Russian and Chinese political interests align. So the Russians managed to send a clear message to the Syrian government that you're covered, you're protected. Do not worry about the Security Council. We got your back on this one. Do what you got to do. And hence the increase of the use of power and violence and deployment of artilleries, and then later helicopters, fixed-wing aircraft, and then later the use of chemical weapons, which at the moment in 2013, you would think this is a point where the UN and the Security Council and the world would stop, have a hard stop, and rethink twice what's happening, try to get to an alignment on Syria, but that didn't happen. Russia threatened to veto any referral, any comments about or resolution on accusing the Syrian government of the use of chemical weapons. They struck a deal with the United States politically outside of the Security Council to disarm the Syrian government from its chemical weapons arsenal. But later in 2014 came back and vetoed with China an attempt to refer Syria to the International Criminal Court, which put an end really for any potential for accountability and justice under the International Criminal Court at the time. When the use of chemical weapons continued later, the OPCW, the Organization of Protection of the Use of Prohibition of the Use of Chemical Weapons, had a joint investigative mechanism with the Security Council, usually referred as the Joint Investigative Mechanism, or the JIM. The JIM was mandated to investigate the use of chemical weapons. So the creation of the JIM was a very difficult process, was negotiated between Russia and the United States, provided the United States will not launch a military strike on Assad outside of the Security Council. So the threat of using force outside of the Security Council is the only way that allowed Russia not to threaten to veto or to veto on the Security Council. That's one of the angles or the sides of how deep and complex this problem. And later, Russia has manipulated and threatened and basically tried to dismantle the work of the JIM altogether. So they vetoed the renewal of the JIM the first time in October 2017, and then they vetoed in November 2017 twice back-to-back in 2 days. A Japanese proposal to extend the mandate of the JIM for 1 month only was vetoed, and the second day a proposal to extend the investigation of the JIM was also vetoed back-to-back in 2 days. This tells how much political influence the use of veto power is putting on the P5s and hands in general, but also it tells how much these countries going against not only the UN Charter, but also against specific obligations under some treaties. The UN Chemical Weapons Convention obligates states to investigate the use of chemical weapons and to assist in these investigations. So to see Russia preventing another UN investigation that's Russia supposedly required under the UN Chemical Weapons Convention to investigate or to support the investigation, that's even another layer of the problem. So the whole practice of Russia and China around the Security Council, the use of veto, of course, clearly, as Jennifer mentioned, the threat of use of veto discouraged Jordan and Kuwait and Morocco a couple of times from proposing basically resolutions to go to the floor. And some of these resolutions were as simple as condemning the use of violence from all parties, or condemning the use of chemical weapons from all sides. And Russia started to manipulate the process even further with the JIM specifically, when they start conditioning the finding and the results of the report. So I remember Sergei Lavrov's comment, if the JIM investigative results found that the Syrian government was responsible, we're going to veto the renewal of the mandate of the JIM. So that showed actually there's not only protection of, not only facilitation of committing atrocity crimes, but also covering up and blocking any efforts on justice and accountability. I'll stop here. One comment I have to make before I move is, we'll get back to this more, that the Russian and Chinese veto kind of handcuffed the United Nations altogether. When the United Nations tried to cross the border and cross the line with Russia, and they did cross-border operation in Aleppo, humanitarian aid delivery in 2016, 14 trucks of the basically vehicle and trucks from the UN was bombed by the Russian aircrafts in response to that basically step from the UN. And that kind of forced the United Nations to go out of the Security Council and move to the General Assembly, where nobody can practice veto specifically. And they managed to create the IIIM, the Independent International Impartial Mechanism to assist in the investigation in Syria. We'll get back to the IIIM, the formation of it, and how actually the P5s are weakening their role in the Security Council by allowing the member states to go to the GA, to the General Assembly, to propose this solution. Because if you're constantly vetoing anything we're proposing, we're going to dump you all together and go to the GA. And now we've seen there's the IIIM for Syria, and there's an investigative mechanism for Iraq under the General Assembly, and there's similar mechanism for Myanmar under the General Assembly, because we have to escape Russia and China and all the blockers and the Security Council. I'll stop here and get back to the IIIM.
Okay, great. Thank you. That as you explained, the Syria example really shows then how the use of the veto and the threat of the use of the veto affects not only the conflict situation itself and UN practice, but also the action of states outside of the Security Council itself, as you showed. I'd also like to get back to the point of the other obligations under the UN Charter and other conventions that you mentioned, but I think we'll touch back on that later in our conversation. So I think next we'll go to you, Ambassador Carell, hoping you can give us an overview of the different initiatives that UN member states and scholars and others interested in this issue have come up with in the past decade in attempts to address this issue and kind of stalemate, and your thoughts on how the promise or challenges in those various initiatives.
Yes, of course, I followed the Security Council almost on a daily basis during the 10 years I was the legal counsel of the United Nations from 1994 to 2004. And I came to the conclusion that it's extremely sad that the Council simply can't perform in the manner that they should. And I think that in many cases, the use of the veto is simply not legitimate. They are just protecting friends and so forth. I think the idea with the veto was that if the permanent members themselves felt that there was a threat and so forth, then they could veto, but not just throw in vetoes when it suited their friends and so forth. And when I left the United Nations, I thought a lot about it, and then I actually took an initiative. I wrote a letter on the 10th of December 2008 to all members of the UN, referring to my experiences from the UN, and said, it's very difficult to change the charter, and the veto powers will never agree to limit the use of the veto by changing the charter. But I said they could adopt a declaration, a voluntary declaration, where they declared 4 elements. I suggested this for food for thought. The first element would be, from now on, we are going to bow to the law that we are set to supervise, namely the UN Charter. Is that asking too much from the permanent members of the Security Council? If they do not abide by the law they are set to supervise, what signal does this send to the world? Second element was, we are not going to use the veto unless our personal own concerns are on the table. Then we may use the veto, and if we do, we will explain why we do so. The third element of the 4 was, from now on, we are only going to use force in accordance with the UN Charter, either in self-defense, according to Article 51, or if there is a clear and unambiguous resolution by the Security Council to use force. And then lastly, the 4th element, from now on, we are actually going to use the responsibility to protect mandate that we found in the General Assembly resolution on responsibility to protect. If a state is unable or unwilling to protect its population from genocide, war crimes, crimes against humanity, or ethnic cleansing, then we are going to intervene if necessary, by force. And I know that this suggestion was discussed among members of the Council, but nothing came out of it really until in 2013, France made a proposal along the same lines. And there was a discussion in the General Assembly about this also. And then Mexico came on board. So France and Mexico made a proposal that has attracted quite a lot of attention here. But I think the latest development is perhaps the most interesting. It was launched in 2015, and it's called a Code of Conduct, where all member states of the United Nations say that if we are members of the Council, permanent members or elected members, we are not going to veto a reasonable resolution that is to address the situation where people are being subjected to genocide, war crimes, crimes against humanity, and ethnic cleansing. And that has attracted more than 100 states have accepted this code, including 2 permanent members of the Security Council, namely United Kingdom and France. So I think this is something that we should see if it is possible to go down this avenue. But this means that this is a voluntary undertaking. And I don't think it's any point in starting to amending the Charter. As a matter of fact, I'm warning against amendments to the Charter, even when they're now discussing just extending the membership of the Council. I can't think of a more effective manner than killing the executive body, the Council, if you just add more members. I think 11 more members is the latest bid in the discussions. The Security Council is an executive organ. It has to act under the rules of the Charter. And an executive organ is always a small organ. It can't be democratic in the sense that everybody should be on board, but it should be representative for the United Nations. And I think it's so extremely important that something happens here. So my hope is that in the discussion here, this will be something that could develop into a change in the behavior of the Council without amending even a comma in the Charter of the United Nations. But then there are other steps that Jennifer Trahan is discussing, and I'm very interested in those steps now. But for the moment, I'm looking at this voluntary element here. Could I add also that Kofi Annan visited Uppsala University a few years ago, and he had a discussion with Jan Eliasson, who had been Deputy Secretary General of the United Nations. And I was asked to comment on that discussion. And when I did that, I challenged the students at Uppsala to sort of line up against the use of the illegitimate vetoes. And they formed a campaign, the campaign against illegitimate vetoes. And they have analyzed the 50 vetoes cast after the Soviet Union became the Russian Federation. I think that's 91. That's a natural line to draw in history. And they have analyzed 50 vetoes cast. I think 11 by China, 13 by the US, sorry, I think I had a figure there, 23 by the Russian Federation and 16 by the US, 50 in all. And they've come to the conclusion that 48 of these vetoes are not legitimate because they don't concern the security of the member itself. They are just supporting friends to protect them from actions that the Council should actually take against those friends. So it's just an interesting idea. Just look at it. Campaigned against the illegitimate vetoes. Thank you.
That's great. Thank you so much. Professor Trahan, could you first, I guess, I'd like to follow up on something that Ambassador Carell mentioned at the end, the idea of illegitimacy in the use of the vetoes. He kind of gave us an intro to that idea, but I'm wondering if you could expand on that first and explain the idea that a veto could be illegitimate, noting the obligations in the UN Charter, and then like you to talk about your ideas and what you've been studying on the legal and practical challenges that these different initiatives face, and maybe some ways forward about how the problem could be addressed in the Security Council.
Great, thank you. Just first to say I'm in complete agreement with my dear friend Hans Carell that there's veto power over amending the Charter. So amending the Charter is essentially, not a possible route to go. The veto can't be touched in that way. And he mentioned the voluntary veto restraint initiatives we've had, and we've had these for about 20 years now, starting with the International Commission on Intervention in State Sovereignty. They come out already in 2001, because R2P can, of course, be completely blocked by the veto, as we've seen in Syria. So I think these are very important, and they've really galvanized momentum. I think the Code of Conduct has 119 states joining, and the French-Mexican Initiative 101. So it's almost 2/3 of the GA says the veto shouldn't happen while there's ongoing atrocity crime. But really, our problem is there are 3 P5 who won't join these. So in the end of the day, we don't have voluntary veto restraint when not all P5 will endorse these. So I've thought of a different way of approaching the issue, and that is to look at it from a point of legality. And I've thought of 3 arguments, and they are in an attachment, which I believe people logging in have access to, so I just very briefly have them there. But my arguments are, first, to question the relationship of the veto and jus cogens. So we say the prohibition against genocide, war crimes, crimes against humanity are all the highest level of norms, jus cogens. So then my question is, if the veto, which is found in the UN Charter, can it be freely used when it is certainly being used in a way that's completely inconsistent with jus cogens? You could even say it's facilitating jus cogens violations. Well, all bodies under international law are bound by jus cogens. The UN is bound, states are bound. Ergo, the Security Council is doubly bound. It's made up of states, but it's also bound as an organ of the UN. So its veto use is inconsistent. At minimum, and more aggressive formulation is they're actually facilitating jus cogens violations. A second argument one might consider is the relationship of the veto, which sits within the context of the UN Charter, with the other parts of the Charter. So the Charter has purposes and principles, and there must be respect for human rights, for international law. There's basic requirement of good faith. And 24.2 of the Charter says the Security Council is bound by the purposes and principles. So this is a limitation on its action, that the Security Council can't violate the purposes and principles of the UN. So I would argue Article 27, containing the veto power, has to be read in conjunction with Articles 1 and 2 of the UN Charter. The veto power can't violate the Charter. And that's where the power comes from. It can't be exercised in a way that's beyond the Charter. And I think the vetoes we've seen are being used in that way. So a third argument one might consider, Mohammed mentioned the Chemical Weapons Convention. I would also add to that list the Genocide Convention and the obligation to prevent genocide. And we have a ruling out of the ICJ on the Bosnia-Serbia decision that says a state must do everything in its capacity based on its position of influence. Well, if you think of the P5, they have particularly strong positions of influence. The P5, if they're intervening in a situation or have ties to the regime in question, they have even more strong positions of influence over that government. So they must do everything in their power to ensure genocide isn't occurring. And I would look at, the Myanmar veto in that light. And then under the Geneva Conventions, the 1949 Geneva Conventions and Protocols 1 and 3, there's an obligation to ensure respect for their provisions. And where there is an extraterritorial component, ensure means including in another state. So it's not just on a state's territory. Are the vetoes that we've been seeing trying to ensure the Geneva Conventions are protected? You look at, Mohammed mentioned humanitarian assistance, trying to get into regarding the siege of Aleppo, that gets vetoed. Is that trying to ensure respect for the Geneva Conventions? It seems the absolute opposite. So permanent members have obligations under these treaties, I don't think they shouldn't be violating them. Now, someone might argue under Article 103 of the Charter, they're free to violate, citing Lockerbie. That was an aviation kind of convention issue. It really wasn't about genocide. So these are not just any treaties, these are incredibly foundational treaties. And I don't think the council members lose their responsibilities when they walk into the council chamber. So those are my arguments, and then my overall idea is the General Assembly should ask the ICJ for an advisory opinion on a question such as if genocide, war crimes, crimes against humanity are occurring, can the veto still be freely utilized under obligations of international law? Some kind of formulation like that. The General Assembly should put to the ICJ to really help stop this problem. Thanks.
Great. Ambassador Carell, are you interested on commenting on that point specifically?
Definitely. I think this is a very important question. As I said, when I started looking at this, I started with this voluntary declaration that they could accept. But I understand that this has perhaps come as far as it can. And then you have to look at other options. I think that these options that Jennifer Trahan is discussing are extremely important. And the General Assembly should actually ask the General Assembly for a legal opinion, or for an opinion on this question. And they have done so in the past. For example, there was one case when they asked the court for an opinion on a Security Council resolution on Namibia and South Africa, and where they came to the conclusion that an expression by the Security Council in this and that way, that expression means that all states in the world are bound by that. So if they can make a pronunciation like that, they can definitely make a pronunciation on the principal question, what if a resolution adopted by the Security Council is violating the Jus Cogens, the always binding international law? That would be absolutely possible. And I mean, I'm looking at the JCPOA, for example, the agreement on Iran on the nuclear issue, where the US has withdrawn all of a sudden. I think that the US could not withdraw from that agreement. And even if they did withdraw, they are still bound by the Security Council resolution endorsing that agreement, as all states in the world are bound by that resolution. So you can see here how resolutions by the Security Council work, and therefore it's possible to have a legal opinion from the International Court of Justice in this matter.
Great. And for our listeners, could you quickly explain the International Court of Justice and how a case gets there, for example, by the General Assembly? Anyone?
Well, I mean, the International Court of Justice is one of the 6 organs of the United Nations. It's not situated in New York. It is situated in The Hague, in the Netherlands, in the Peace Palace. And there the judges are elected for certain periods, and then they are adjudicating cases between states. But they can also give advisory opinions according to the rules of the court and the UN Charter. And those who can ask for advisory opinions are the General Assembly, for example. That's one of the bodies. There is one idea that the Secretary General should also be authorized to ask for advisory opinions, but I have been hesitant to support that idea because it would press the Secretary General under enormous pressure to ask about this and that and that. I think it's better that it's the General Assembly or another organ of the UN that asks for this kind of advisory opinions. But it's extremely useful and important feature in the work of the court, as it were.
Okay, great. Before we move to my next question, I just wanted to remind listeners that you can ask questions to the panelists. I think we're nearing the end of our discussion, and then we'll have plenty of time for questions, and this is a really interesting issue. So if you have a question, please put it in the box on the side of your screen, on the right side of your screen that says questions, and I'll be able to see it, and then I can ask our panelists. So feel free to put those out anytime, and I'll collect them and ask some of them at the end. Next we're going to go back to you, Mr. El Abdallah. I'm wondering if you can talk more about how these challenges, different initiatives, stalemates have affected, in your view, the institutional role of the Security Council and its role in maintaining international peace and security.
Yeah, absolutely. I mean, I think it's explained really well by both Jennifer and Hans. When you block the Security Council's ability to react, to conduct the duties and principles, basically, the Security Council was basically created to uphold, then you're creating a parallelized body. So you're blocking the Security Council from working. You're forcing member states to either go outside the Security Council, like what happened in Syria and Myanmar, or to negotiate inside the Security Council, like the case in the investigative mechanism in Iraq, UNITAD, but to limit the mandate of the UNITAD to fit all the P5s so nobody can veto, so you can guarantee no veto. So that basically is a setback for justice and accountability. That's a setback for the peace and security that basically the Security Council supposedly upholding and trying to protect. And also it's weakening the Security Council, because the more you pressure, the more you're going to lose influence, because you're pushing these member states to go outside and look for alternatives. They don't want to come back to the council. The other alarming point is what's happened between the United States and Russia on the chemical weapons. The use of chemical weapons in 2013, in August 2013 in Syria, President Obama announced basically the US has enough intelligence to confirm that the use happened by the Syrian government, and the Syrian government is responsible for that, and the United States is planning a military strike to punish the Syrian government. The Russians jumped in the middle. They tried to intervene in this. They couldn't defend Assad militarily against the United States, but they tried to strike a deal with the US, and that's what happened. Sergei Lavrov and John Kerry sat together and agreed on something. And then they brought the agreement they had outside of the UN and they cashed it on the Security Council. And this is another alarming point. We're going back to the kind of the Cold War tactics. Let's agree outside the Security Council and let's come back and vote on it. And if the big guys are in line with this, nobody will can do anything. They cannot veto. They cannot do anything. Similarly, in places where the veto could have been basically avoided by just agreeing on simple phrases or not. So the threat of the use of the veto by Russia and China discouraged member states, including the Arab blocs. Basically, at some points, I think Morocco was in the Security Council in February 2014. February 2012, when the second double veto happened, Russia and China. And basically the Moroccan ambassador was very hesitant. Should we put the resolution forward or take it down? The Russians are threatening to veto. So the collective agreement was like, let's put it forward and let them veto in front of the world. So let's use that against them as an advocacy manner. So the more the P5 uses the veto power on cases where there's atrocity crimes happening or a humanitarian crisis happening, and basically the world attention to these crises, I think they're losing their power ultimately, because they'll ending up with a mechanism they don't have a veto power on, like the IIIM now in Syria. And Russia's response to the IIIM, that is illegal, just one line, like this is a legal mechanism, we're not engaging in it. And when they couldn't really undermine the IIIM's legality or the IIIM establishment, especially with the wide support from the GA, 105 members, 105 members voted yes versus 15 only voted no. And the General Assembly, they started harassing IIIM, and as they do with the Commission of Inquiry, they sit in the budgetary committees in the UN, and they start going line by line in the expenses of these entities, how much they spend on their investigation or not. And this shows that actually a permanent member is undermining the UN work again.
Certainly. Could you or anyone else, if you care to, explain you mentioned the IIIM, could you explain that investigative mechanism and how that's different from other accountability initiatives that can go through the UN system? Because it's kind of a novel situation.
Happy to take it, but if Jennifer and Hans wants to.
Well, I mean, the difference is, of course, that if the court is established, then it works like a court, like the Yugoslav Tribunal, like the Rwanda Tribunal, and also the International Criminal Court, that was negotiated in Rome in 1998 and which entered into force on the Rome Statute on the 1st of July 2002. And there, under that statute, the Security Council can ask the prosecutor to look at the situation, a specific situation, and that is to avoid that the Council has to establish new Yugoslav Rwanda tribunals. They can go directly to the existing international court. And even if the state where the crimes have been committed is not a party to the Rome Statute, it doesn't matter. The Council can ask the prosecutor to look at that situation, and then the prosecutor has to follow the evidence. The other things here in Syria, that's different. They are collecting evidence. And of course, that evidence can be used in further. And I remember when I was a war crimes rapporteur in the former Yugoslavia, in our first proposal, we said that they should set up a committee to draft a statute for the court. But in the meantime, they should organize proper gathering of evidence, because we were afraid that evidence might be destroyed if it's not done professionally. And then, of course, when nothing happened, so in November 1972, we were asked by, we offered and we were asked in December 72 to draft a statute for the court. But this was a very important element that we saw immediately, that it's important to gather evidence in a professional manner. And then how this evidence is going to be used in the future, that's a different thing. It could be used by an international court if such a court is set up. It could be used by national courts in the territories, and it could be used in national courts where citizens who have been committing crimes in Syria, for example, are brought back to their countries and brought to justice before the national courts in that country. So it's very important to gather this evidence. Yep.
Great. I'll remind listeners you can send in questions on the right side of your screen in the questions tab, and they'll show up and I can ask the presenters. So we've question.
Maybe I'll just add, Kristin, as we're waiting for questions to come in. So with all of these investigative mechanisms, Myanmar, the UNITAD one, which is solely for ISIL crimes in Iraq, as well as the IIIM for Syria, they aren't accountability mechanisms, they just collect the evidence. So they're like step one, and step two would be referral, it would be creation of a tribunal, it would be creation of a hybrid, it would be some mechanism that actually can do the cases. So they're only the first step. Sometimes they're referred to as accountability mechanisms, but they're not. They're just evidence collecting. And I think it'll be really problematic if that's where the international community is stuck and we just collect evidence and go home and call it a day. So I think it's really, it will be necessary in the future to ensure for all three of these instances that the information can actually be utilized in court proceedings. So that will be a challenge for the future.
Sure. Okay, we have one question kind of going off that point, so I'll go right to that. Is there a coalition collecting this type of evidence or international legal research for a future tribunal or domestic human rights cases against the regime? I assume that's in reference to Syria, perhaps. So maybe we could talk about what accountability mechanism, oh, they said yes, it's in reference to Syria. So maybe we could talk about a little bit how we talked about that mechanism coming from the General Assembly.
There's a couple of things happening. There's the Commission of Inquiry was established by the United Nations Human Rights Council in Geneva. So the COI, the Commission of Inquiry, reports to the Council, under the Office of High Commissioner for Human Rights. They do public reporting, collection of documentation and evidence. They've done interviews, around 6,000 interviews with survivors. And they've done lots of reporting, and their reporting got escalated as the conflict escalated in Syria. So they ended up in some reporting in 2017, basically accusing Russia directly of basically conducting violations and the bombardments of Aleppo, and those amounted to war crimes and crimes against humanity. Outside of the Human Rights Council, after the veto or the double veto on the ICC referral in 2014 and the siege on Aleppo and the continuous fight, the IIIM emerged, and the IIIM is indeed collecting evidence and preparing basically cases to be pushed for tribunal, either tribunal showing up at the end of the conflict by the UN again, or domestic trials inside Syria, or even under the universal jurisdiction in Europe. Certain countries have the jurisdiction where the judiciaries or the justice authorities able to initiate trials, and this is happening in Germany, in Sweden, in Netherlands, in France, and IIIM could be contributing cases to those prosecutors in general. There's also the civil society efforts on documentation. We've done a mass amount of documentation, around less than 1 million videos so far. We've basically preserved. Today we just launched a report analyzing 5,000 pages of the intelligence archive we managed to rescue from inside Syria. That's getting some media attention. So there's the civil society side of the work, the Syrians who've done the documentation and the collection. There's also the COI and the IIIM, and there's like wide array of activities and initiatives in between as well.
That's great.
But I think they have had problems. The commission set up by the Human Rights Council, I don't think they have been able to visit the area. So they've had to make their investigations by hearing people outside the area or by telephone or video links and so forth. But because I read a study where they explained how they had worked. But as you said, Mohammed, 7,000 inquiries they have made to both witnesses and victims.
Correct, yeah, since it's a UN mandated entity, so they have to get the Syrian government consent to be able to present inside the country, and that's impossible. So they do work with survivors across basically the borders, ended up in Turkey, Jordan, and Lebanon. And also they did the video conferencing, and we worked with them in a couple of investigations because we're Syrians, we present inside the country. We don't need anybody's approval basically to work inside Syria. And that's part of the partnership between Syrian civil society and the COI and IIIM from other side.
Excellent. I have a question. I guess we mentioned in talking about the ways the Security Council works, some of its challenges, the concept of the responsibility to protect. I'm wondering if one of you could expand on that a little more for our listeners that aren't as familiar with it, and how that interacts with this issue of vetoes in the Security Council.
Well, I mean, there is the resolution by the General Assembly adopted on the responsibility to protect, and there are 2 paragraphs. I think it's 138 and 139, or is it 2?
Yeah, no, it's 138 and 139.
Yeah, 138 and 139, and the first one explains that states have responsibility to protect their populations from genocide, war crimes, and crimes against humanity, and ethnic cleansing. But if they fail to do so, there is an obligation on the Security Council to act. And this obligation includes acting under Chapter 7, which then provides for the Council to decide about using force if necessary. And then, of course, they have to act under the Charter, as we discussed in the beginning of this webinar, but they have an obligation to do so. And this is what I think is so important, that they actually act. Before this resolution was adopted in the beginning of the 20s, when I came to the UN on the 6th of March 1994, 1 month later, the genocide in Rwanda broke out. And I will never forget Boutros Ghali, the Secretary General's desperate cry for 3,500 troopers, that the military said that would be enough to stop the genocide that was spreading. No state was prepared to provide those troops. And then I was also aware of a situation where you can actually watch what is happening and nobody is doing anything about it. And I think also it is important to prevent these kind of things happening. And this is where I see the tragedy in the manner in which the Security Council behaves. If they, for once, could put their foot down and go after a dictator or a warlord who is committing these crimes, that would send a very powerful signal around the world that I'd better be careful, because if I'm doing this or that, the Council might come after me. And I remember that when Kofi Annan was given his task to be the rapporteur for the UN and the Arab League in Syria, he was the first one to be given that charge. We were sitting here in Stockholm discussing whether we could work in Syria as we had worked in Kenya after the 2007 presidential election, when the African Union asked Kofi Annan to come in and become the chairman of the panel of eminent African personalities, together with Benjamin Mkapa from Tanzania and Graça Machel from South Africa. He managed to get the parties to sit down at the conference table and to negotiate an agreement that was transformed into a grand coalition government. And he said, can we do the same thing in Syria? And then he fell silent, and then he shook his head and said, no, Hans, we can't. I do not have the support of the Security Council. That is a precondition for succeeding with this task. So I'm going to leave it, which he did in August 2012. It was very sad. But he was so aware of this. And he was not a lawyer, Kofi Annan, but he had better understanding than many lawyers about the importance of the rule of law for international peace and security. A rule of law means also criminal justice. And criminal justice at the national level is there for two reasons, of course, to punish those who commit crimes, but above all, to signal to people that certain acts are criminal and you shouldn't commit them. That's called prevention. And this is what the Security Councils could do. They could prevent conflicts in the world if they acted truly under the Charter.
Certainly. Thank you for highlighting the link between this issue that we've been discussing and atrocity prevention. As you said, kind of a cycle between accountability and prevention. Another question I'd like to ask is, if we could we talked a little bit about how the Security Council interacts with the International Criminal Court in a basic way. I'm wondering if we could talk about that a little more, perhaps including the cases where the Security Council has acted in referring a state to the International Criminal Court, how that's gone. I think there are challenges with those as well. So if anyone wants to expand on that, I think that'd be interesting.
Yeah, I could jump in on that. There have been only 2 referrals, the situation in Libya and Darfur, Sudan. And particularly the Darfur situation has had almost all of its warrants outstanding for many, many years. And I think one of the difficulties is with Security Council referral is the Council seems to view it as a one-off. I mean, don't get me, I'm glad when there is referral. Syria, it was simply completely blocked. And Myanmar, we don't even talk about it because it's completely blocked. And that's where my initiative comes in. I think those are not in accordance with international legal obligations to do that kind of blockage when there aren't alternative accountability options. I'm not saying you always need to refer to the ICC, but if there's nothing else happening, then if you are blocking referral, you're blocking investigations. In the obligation to prosecute, which we see in Great Breaches, it's read into other treaties. There's case law, it's implicit, you have to investigate. So when you're blocking referral, you're blocking investigations and prosecutions. But even when we have referral, I think the Security Council needs to improve to make sure that there's follow-up. There are now outstanding Libya warrants as well. And whereas there was a ruling that Abdallah al-Senussi could be tried in Libya, Saif al-Islam al-Qaddafi was supposed to be transferred to the ICC for trial. This hasn't happened, and of course, almost all the Darfur warrants are outstanding. So the Council kind of sees it, I think, as a one-off. We do a referral and then we wash our hands, and we don't really have to do anything. And this, then again, you know, is the Council serious about these referrals? Did it really mean to be advancing accountability, or was this just window dressing? So, you know, so I think we need to have evolution in how the Council addresses referrals and follow-up. It could very easily have follow-up attention to these, and it simply hasn't.
Absolutely, and I'm very critical in case of, for Sudan, for example, if the evidence leads the prosecutor to the head of state and there is a prosecution, the Council shall order the state to deliver the person to the court. They have to be consequent here. And I mean, the purpose of the International Criminal Court is to bring to justice people who otherwise would never be brought to justice. This is so important.
Certainly. Thank you all. I'm just going to put one last shout out if anyone has any additional questions. We've got a few minutes left, though we're coming towards the end of our webinar. One question is, where can someone get more information about the topics? So that's good. We've sparked a conversation at least. I think there is a handout available on the screen, but we could also provide some more links on places where you could read. Additionally, I know we've talked about a lot of legal concepts, both within the UN Charter and that legal structure, and also related institutions like the International Criminal Court, and the responsibility to protect and all those types of issues. So we could link to some of those.
Yes, definitely there is. And if you're interested, if you Google my name, Hans Carell, you will find my homepage, and then look under the United Nations, where you will find articles on the UN and the veto and so forth, with links, importantly, links to institutions and elements that you might find interesting to study. So that would be one suggestion. And also, Jennifer, you have material that you have provided, including the very short paper, which is very illustrative for this webinar that you provided. So there are elements, definitely. And also there are others who are interested in this. In the US, for example, we have David Crane, who was the founding prosecutor of the Sierra Leone Tribunal, who is very active in this field, and also the Robert A. Jackson Center in Jacksonville. That has material that could be interesting. Also, every year there is in the Chautauqua in the state of New York a meeting of prosecutors, and they issue a statement together for that. So Chautauqua institution and the meeting of the prosecutors of the international courts, that's very useful in material.
Yes, thank you all. Now we've got some questions coming in, so I'm going to try to get a couple of them at least on the table in the few short minutes that we have left. One person is asking for, in terms of atrocity prevention, for a little more detail on how an ICJ advisory opinion could effectively prevent atrocities. So maybe just a little more information on the types of legal obligations that would entail or try to address.
Jennifer, why don't you answer that question?
I'll try to do it really quickly because I know we're running out of time, but
you have still 3 minutes.
Okay, so Hans talked about Security Council action, but there are often times when the Security Council doesn't really have maybe a plan, but kind of step one is simply to condemn the crimes. And if you condemn crimes, you're trying to prevent more crimes. So I'm not only complaining about veto when there's kind of a plan to marshal a response, which in Syria there never really was a plan other than peace negotiations. But step one is really to call out the crimes that are occurring. And even that was blocked in Syria. Just long lists of crimes, and they can't even get the resolution out. So when it's being blocked, you're doing the antithesis of prevention. So by attacking the veto, you are addressing the prevention component, because there's no prevention. When you block a referral to the ICC, you're blocking any kind of prevention. So I do think there is that tie-in.
Great, thank you. One last question. Somebody noted the challenge in holding Security Council members, including the United States, so those that have that veto power, accountable, and the idea of exemption from accountability, and are wondering how that affects their work and their quality. This person's used the word on the Security Council.
So my idea is just to get kind of a general ruling from the ICJ. There are legality limits on how the veto is used. So that's not really, calling out any single one of the P5, it's really to all of them. It's not necessarily accountability. I mean, I think we do have serious US and accountability questions. That's maybe another topic for another day. With the dismissal of the Afghanistan preliminary examination. subject potentially to appeal. But so my idea is to kind of get a general ruling from the ICJ that would hopefully, it would be non-binding and it would be an advisory opinion. It's non-binding, but I think it still would carry serious weight.
Yes.
So that was my idea.
It is so, and it's also the moral question that states do not like to be called in question when they act. And my concern, my true concern is what we need on the Security Council, and in particular among the 5 permanent members, is statesmanship. Statesmen and women who can look to the horizon and realize that they have a responsibility not only to their own countries, but to humankind, because of the central function they have under the UN Charter. And also they have a responsibility not only to the present generation, but also to coming generation. And we will see this increasingly, in particular when climate change will start affecting peace and security on the globe. And climate change, here the US refused to introduce those 2 words in the declaration by the Arctic Council a few days ago. This was historical. And I think it's so sad when states that should know better deny the advice that we receive from science when we come to these questions. So I'm very critical, and I'm missing statesmanship, statesmen and women who can look to the horizon and understand their responsibility.
Thank you. That I think I'll ask one quick question and then we'll be done. We'll wrap it up. One attendee wanted to know if there's an example that comes to mind of the Security Council really getting it right or being very effective. Maybe not, but if anyone has one in mind, that'd be interesting as well.
I didn't understand the question. That's a council.
If there's an example you think of the Security Council really getting it right and taking action on an issue and being effective.
Yes, I mean, they did twice in the 90s, for example, when they established the Yugoslav Tribunal and when they established the Rwanda tribunals, and then they followed suit. And those tribunals worked in the manner they should. So I think this proves that when the political climate is right, they can achieve a lot. But now in the later years, we have gone backwards. And I mean, one of the worst situations during my time in the UN was when the US and the UK attacked Iraq back in 2003. That was a flagrant violation of the UN Charter. And then came Russia in Georgia in 2008, and then the latest in Ukraine. When permanent members of the Security Council violate the very charter they are set to supervise, what signal does that send to the world?
It's a great example. Anyone have any last words they want to add before we wrap up?
I'm going to go back to Iraq in 2003 because I remember exactly the words. I'm still living in Syria and studying law in Lebanon. Basically, the threat was if any of the P5, like UK or France mainly wanted to veto. France, Belgium, and Germany formed the coalition opposing the invasion of Iraq. So the United States threatened to go in a war without a UN Security Council coverage or without UN coverage, which is even threatening to undermine the UN further if they go. So P5s and the entire Security Council becomes in this kind of a dilemma where if we act, we're going to undermine the UN. If we don't act, we're going to undermine the UN. So the entire system is working on these kind of fine balances, if I may. And this is the way it's been working. It's unfortunately like resulting in setbacks and lots of negative impact on the humankind, specifically in places where there's atrocity crimes. Syria is another place, vetoing humanitarian aid delivery. This is impossible to believe.
Excellent. And anyone else? Jennifer, a last word?
No, I just want to say thank you, Kristin, and thanks to the ABA for showing the initiative to be interested in this issue. I think it's a really, really important topic.
Well, thank you. Thank you. First of all, oh, do you have something, Mohammed?
No, to say thank you.
Oh, okay. So thank you to all our panelists who were wonderful for being involved in this discussion and giving us a lot to think about. Thank you, of course, for those of you who are listening and for the great questions that you sent. Those were really wonderful. The handout is accessible on the right side of the screen, but you'll also get a link if you've registered for the webinar to follow up. That'll have the recording and those materials attached. So look out for that in your email. Otherwise, thanks again. And hopefully we'll see you at another ABA webinar or event soon.
Thank you. Goodbye all.
Thank you.
Thank you. Bye-bye.